Hey, everybody. Um, Estate planning, the nine-step path to securing your legacy. I'm estate planning attorney Paul Rabley. I'm excited about this live stream just because for again, recent development for my technology skills. I'm going to be able to show you, not just tell you, but show you kind of a lot of the different pieces of the estate planning puzzle from all the way going from where somebody says, boy, I really need to get my estate legal affairs in order, all the way through wow. I have everything in place. I've talked to certain members of my family about this. I feel really good. I have peace of mind. So I've broken that down into nine different parts, and I'm going to show you all those parts here this evening. So let's just jump right in. First of all, let me tell you what the parts are, and then I'm going to show you each part, and I'm going to explain it as we go. So part one, it's called the questionnaire and the calendaring the design meeting. Part two of nine parts, setting up your secure online portal. Part three is your estate planning Zoom meeting. Part four is actually we get to work preparing all of the and customizing all the relevant estate planning documents. I'll be showing you what those are. Part five is a combination lawyer and client review and of the documents to ensure everything's 100% perfect. Number six is make those documents official. We show you how to do that. Number seven, how to upload those to your portal so you'll have not only a hard copy but an electronic copy of everything. Number eight is join our community. I'll show you that. And number nine is communicate what you've done to the right participants and the appropriate stakeholders so they know what's out there and what they need to do when the time comes. So a lot to each part. Each part is a moving part. You may think estate planning is just, hey, let me get a will prepared and sign it. So much more to it than that. And so let's jump right in. All right. Part number one is what I'll call the questionnaire and the calendar. Now, I'll be the first to admit there's something like maybe, well, tens of thousands of lawyers who provide estate planning legal services in this country. I'm not here to say that I'm the best, my system is the best, my business processes are the best, but I can just share with you kind of how we typically do it and how it's evolved over more than 30 years of helping people get and keep their estate legal affairs in order. I'll say on the front end, estate planning is kind of still in the kind of archaic area where so much reliance on physical pieces of paper, what we call wet signatures on documents. Really, estate planning legal services has not moved into this 21st century when it comes to taking advantage of some of the technological advances that are out there. However, as part of our nine-step process, we do take advantage of some technology. So in my view, the way we do it, it's kind of a combination of using technology where we can and the old wet signature and documents that get printed and signed with a wet signature on the other. So um, but the goal here in any attorney's process, I'm sure, is to just make sure that your desired objectives are met. Make sure that you're aware of the opportunities and things that are available to you from an estate planning perspective, and so that you can make informed decisions. And then, of course, the goal is for ultimately things to go smooth for your surviving family members. You're doing this for the people that you love, and so you don't want them to have to go through a bunch of difficulty and government bureaucracy and legal red tape. So you want things to go smooth. So that's what this nine-step process was built to enable people and couples and families to kind of get it right, because there's a lot of opportunities for mistake. We want to try to minimize that. As always, hello to all the friends out there, starting with Larry and others, and I see some others saying thanks. Thank you for chiming in this evening. Feel free to throw stuff into the chat. We like to keep those chat comments positive, but we welcome your questions. We welcome your comments. We welcome some, maybe the most important piece is the experiences, sharing experiences that you've had so others can learn from them as well. Feel free to talk to each other in the chat. That's why I do this live, is to create a little bit of a community aspect to these presentations. So excited about that. All right, let's jump right into our 9 steps, and I'm going to show you some things. So the And again, I'm just going to repeat it because it bears repeating. This is our law firm's process. There are tens of thousands of lawyers out there across America who engage in estate planning legal services. I bet if I talked to thousands of those lawyers, or hundreds, or maybe even dozens of those lawyers, I'd pick up things that I could do differently to improve my service or my business processes. So this is me. You may deal with other attorneys. You may have dealt with other attorneys. You may deal with other attorneys in the future, and their process may be somewhat different. But I think the goals are similar. Trying to set things up, give you peace of mind, take advantage of the opportunities that you have to preserve what you have for yourself, for your family, minimize tax, make sure those relationships of those that you leave behind get enhanced as opposed to destroyed because things go smooth as part of the estate settlement process. All those things are kind of typical goals of the estate planning process. Okay, let's jump right in. Our process is a little bit unique because we are unique. Again, not that we're any better or worse or different than anybody else, but our business is set up to help people around the country. It's called America's Estate Planning Lawyers. Most lawyers deal with people sometimes just in their own little geographic area, not to mention maybe just in their state. But we're set up with the attorneys that we have on staff and the attorneys that we have as part of our national co-counsel attorney kind of network. We're able to help people around the country. So a little bit more emphasis on technology than maybe others do because we have to emphasize technology to be able to help people all around the country. Okay, let's jump right in. What happens when just somebody says, boy, and the reason they say it, the reason they start to engage with an estate planning attorney is, they usually, because they tell me how they feel. They tell me something like, Paul, I'm not getting any younger. Paul, my parents just passed away, and we learned some things as we were settling my mother or father's estate. Or, Paul, I know I've needed to do something for a long time, and I just haven't gotten around to it. It's time to get serious about it. Or somebody will tell me, Paul, we did some estate planning 25 years ago. Our kids were 4 years old. The main reason we did it was to name guardians for our minor kids. Our kids are now in their 30s. We need to really kind of start over and get things right. So any number of reasons that causes that trigger for people to say, hey, I need to get serious about getting my estate in order. But whenever that happens with people, at least people that we wind up helping, is they'll stumble upon our website. They may watch a YouTube video and see in the description where there's a link where they can request an estate planning design meeting. So that's where it starts. Let me show you what we have here. When someone does click on that link and request that design meeting, they get a short questionnaire. So the purpose of this questionnaire, this is step number one of 9 steps of getting your estate in order. This is where you're able to share a little bit of information about yourself, what you're trying to accomplish, so that we can evaluate it and make sure it's a good use of both your time and ours for us to have a discussion about what needs to be done and accomplishing all of your estate planning goals. So this is that initial questionnaire that, again, you can find the link to it in the description of this video, where you kind of get entered into our system. It's kind of just step one where you fill in your contact information. We ask some basic questions. Are you married? Are you have kids? And then we get you to check off those top concerns that you have. Again, we're trying to get as much information as we can about you so that when we do have a conversation, we're able to jump right into what's most important to you. So married people often check off, yeah, I want to provide for my spouse, unless you don't want to provide for your spouse, which is rare, but occasionally we hit people who don't want to provide for their spouse. Maybe those older couples who maybe they got married late in life. They got married when they were 70 years old. They each have their own assets. They each have their own families. And when each of them dies, they're going to leave their estate to their children. But most people who are married say, in some form, I want to provide for my spouse. At least maybe give the surviving spouse the opportunity to live in the home for a period of time. But that's one's kind of provide for children. And most people who have children want to provide for their children, so that's pretty easy. Most people check that. Appoint people to oversee the settling of my estate. Let me go through each of these real quickly. Whenever someone does estate planning, they designate, okay, when I die, who's in charge of getting everything settled? Who's going to wind up, paying any final bills that I have, my funeral expenses, any credit card, debt that I may have that's still outstanding when I die? Who's going to go to my financial institution, my bank, my brokerage firm, pool all those assets together in a trust account or in an estate account so they can be dealt with and dispersed ultimately to the trust beneficiaries or the estate's heirs? Who's going to be in charge of determining whether my house gets sold? And if it does get sold, who, that person will be in charge of putting it up for sale, negotiating a purchase price, attending the closing. So when we say appoint people to oversee the settling of my estate, that's what that involves. Prevent one or more beneficiaries from inheriting in one large lump sum. So that's a common one when someone says, yeah, I need to get my estate affairs in order, but if I leave this child $1 million, they'll blow it. Or some people say, Paul, if I leave them a nickel, they're going to spend a quarter. So that's somewhat common these days, and it's not necessary in many circumstances where you have mature, responsible adult children. No need to restrict their access to it to keep them from being able to do what they want to with their inheritance. But when we do prevent people from inheriting in a lump sum, it typically means leaving their inheritance to continue to be managed in a trust for them, so that they get perhaps distributions of income, perhaps annually, and distributions of principal, maybe at certain ages or in certain stages, or maybe they get a monthly payment that may increase adjusted for inflation each year, and that monthly payment will go on until their inheritance runs out. Maybe you leave it in a trust because you have a child with substance abuse problems and you don't know if they'll ever kind of get it right. So you'll leave it in a trust, give a trustee that broad discretion to be able to make distributions to your child when your trustee determines that it would be in that child's best interest to receive a distribution. So that's what we talk about when we say prevent one or more beneficiaries from inheriting in one large lump sum. Avoid the 40% tax. We talk a lot about the federal estate tax on our YouTube channel. If you've watched a few of my videos, you know that we have a $13.61 million federal estate tax exemption for people who pass away in 2024. We know it's going to go up in 2025. And we know unless Congress votes permanent votes to do something different, the estate tax exemption will be cut in half in 2026. When people pass away in 2026, the exemption will be probably based on some inflation adjustment factors, $7 million and some change. So some people check off, I want to make sure that we do what we can do to avoid the 40% federal estate tax. Make it easy for one or more to handle finances. So this is all about who's going to be that agent on your durable power of attorney. I'm going to show you a durable power of attorney here in a few moments. But and so this is where who you appoint as your agent. Sometimes that person is called an attorney in fact. Who do you appoint as the alternate agent? Many married people appoint their spouse first, maybe an adult child as the backup. That's all during your lifetime. If you get to a point where you can't handle things for yourself, you can't pay your bills, you can't access money in your account to pay your bills, you can't deal with your taxes, you can't sell a vehicle that may be in your name that needs to be sold. This is who do you want to be able to do that stuff for you without having to go through a very difficult court proceeding or guardianship proceeding where a judge has to declare you incompetent, a judge has to appoint a legal guardian for you. All this incapacity planning is designed to eliminate that court involvement in that court guardianship proceeding. Next checkbox, make it easy for people to make medical decisions. So in most states, you're going to do some kind of durable power of attorney and enable your trusted loved ones, whoever you select, to be able to handle your money and your business and your property for you. And then on a separate instrument, sometimes called a healthcare power of attorney, medical power of attorney, advanced healthcare directive, healthcare proxy, you'll be designating, and it might be the same people. Who do you want in the event, let's say you're in a surgery and doctors need to talk to people about treatment decisions, or somebody needs to go get your medical records because you're at a facility and they need your medical records. This is all who do you want during your lifetime to be able to make medical decisions in the event you can't make your own. Again, most married people appoint their spouse first, maybe an adult child as the backup. Sometimes we have discussions about whether you could or should name two or more people to do that jointly or separately. All right, and then there's the life support machines decision. Many people refer to that as a living will. That's where you get to make your decision. Keep your, relieve your closest loved ones from having to go through that burden of having to make the decision to withhold or withdraw life support machines. If you're in that profound vegetative state with no chance of recovery, and the machines are serving only to artificially prolong the dying process. So that's another check mark. Again, the more things you check or don't check, it gives us an idea of, okay, these are the things, they said these things were important to them. We want to make sure we focus on those things during our discussion. Enable your survivors to avoid the court and attorney involved probate. So that's all the avoid probate stuff, where people can arrange their estate to keep it out of that court and attorney involved probate when they die, through designating beneficiaries on certain types of assets like IRAs and life insurance and even other accounts. And then for some assets, moving those into your revocable living trust. I'll show you a revocable living trust in a few moments here when we get to that aspect of the planning process, because things that are titled in the name of your trust when you die, they don't have to go through that court and attorney involved process. Things that are in your name have to go through that court and attorney involved process. So we want to know if that's something you'd like to avoid, and then allow your children to keep their inheritance in the event they get divorced in the future. That's been a hot topic for a number of years. Like most parents tell me, they'll usually tell me something like, we never really thought of that, and I like my daughter-in-law, I like my son-in-law, but the words people tell me when we bring this topic up are, "Paul, you just never know." So that's what they always say. And so many people do like the idea of you leaving your estate to your children or heirs in a way so that it's not likely to get commingled or mixed up with other assets that your child may have with their spouse. Thus, if they wind up subsequently getting divorced, they keep their inheritance, and then your child and their spouse may wind up dividing other assets that they acquired during the marriage. So that's an important, we need to know that. And then appoint a legal guardian. That's if you have minor kids, and so important for parents with minor children, although many of them don't take care of it, because I think a lot of parents with minor children, parents with minor children are typically in their 30s and 40s. And so they kind of feel invincible. They don't take care of this stuff, but it is so important so that parents with minor children can designate who they'd want to serve as those backup parents in the event that the parents pass away before the children reach the age of majority. There's other estate planning issues, but those are the ones that we get people to check. And then there's this really question here that's probably the most important question in this whole questionnaire. It seems like about maybe 80 or 90% have some kind of, I'm getting this started because I want to make sure this happens. And that make sure this happens might be, I've been married before, and I have a child from my prior marriage, and so I want to make sure that my current spouse is protected. I want to make sure that my children are protected. I want to make sure that the children from my prior marriage are protected, or maybe even excluded, whatever the case may be. Might have a child who, just due to some unique family circumstances, maybe they're not mature with money, maybe they have a disability and their inheritance needs to be set up a certain way. So, or maybe just your unique circumstances are something like, I have 3 children, but I want to make sure this one child, after, if me and my spouse become incapable, or when we pass away, we want to make sure that this one child of ours, kind of, we want to make it easy for them to make sure everything gets divided up 3 ways. Or it might be the divorce proof thing. It could be any number of circumstances. Every family is unique. And I've told people before, I've been doing this for 33 years now. And I'm for 33 years, I've been searching for the first normal family, and I haven't found them yet. So every family's got a few issues there, and that's okay. That's what makes life interesting. So anyway, this is one of the most important questions we'll ask you is, look, go ahead and make sure if there's anything, and look, some people may think their most unique family circumstance or the most important thing to them. I've had this happen to me before, or I've dealt with a couple, and they have $5 million estate, doesn't really matter what the number is, but I'll ask them this question: what do you want to make sure that we get addressed in this, initial important discussion about, how to leave your life's work, to that next generation? And so, I had one time where a grandfather, he said, well, I really don't care about much. I just want to make sure that my grandson, and he had 7 or 8 grandchildren, I want to make sure that this one particular grandson of mine gets my Ford Mustang. That's all he cared about. So as lawyers are kind of thinking, okay, how am I going to help them minimize the tax burden? How am I going to help them, treat their children fairly or equitably or whatever it is they want to do? How do we make sure we get the power of attorney straight and have the right backups and all that? And this particular client, I don't want to say that he didn't care about all of those things, but he wasn't going to sleep at night until he knew that his grandson was going to inherit his Ford Mustang. So those are the kinds of answers that us lawyers need to hear. And so we need to pull those answers out of you, because your unique circumstances may be just that. They may be unique. And if we don't know what they are, because either you don't tell us, or maybe we don't do a good job kind of extracting that information from you, then things aren't going to go how you'd want them to go. So that is a really important question. And then we get you to, describe what kinds of assets you have. Most people have, home, retirement accounts, all those things. Helps if we know that you own a business, because sometimes there's some special planning with a business. And then just a couple of more questions on the questionnaire here. It helps us know generally what's the total value of your estate. The main reason we need to know that is we need to know whether we need to kind of get in depth and go a little bit deep on whether there's the need to do some particular federal estate tax kind of reduction planning strategies, or at least bring up what some of those options might be, because the estate tax is all based on the fair market value of what you own when you pass away. And when it applies, it's roughly a 40% tax. So we need to get an idea of what you have. And then so that's we're still on step one here, but once you fill that out, and once we review it, and let me stop the share here. Once we review it, and look, sometimes we review things and we just have to tell you, look, I don't think it's a good fit here. I was reviewing, or my staff was reviewing some questionnaires, and one in particular last week, where someone filled out their questionnaire. They wanted to have a discussion with me, or about their estate planning objectives, and they did share some information in their, what do you want to make sure we talk about question. And their answer was something like, Paul, I really need to talk to you really quickly, because my father passed away 3 days ago, and my stepmother went into his house, and she took the entire Tupperware collection out of the house. And now we need to sue her to get his Tupperware collection back. So that's one where sometimes we see some of these questionnaires that are, and we just have to say, look, we appreciate you asking us to have a conversation with you, but this is just not an area where we can help you. Obviously, not obviously, but our law firm doesn't handle any of the kind of contested estate litigation matters where, the heirs are squabbling and everybody wants to sue everybody else. We just, it's not part of our business. Our business is more, how can we help you set things up so that all of that family discord and drama and difficulty, how can all that be eliminated? So and so there's harmony, and family relationships are enhanced instead of destroyed, as part of the kind of little bit of work that we do today. So anyway, we look at your answers to that questionnaire. We make a determination. Either no, it's really not in the best interests of your time or ours, probably both, for us to have a discussion. Thanks, but we're not going to be able to help you. Or it'll be one of those where, yeah, this is kind of right up our alley. It's somebody, it's a individual or couple who wants to get all of their affairs in order, their main goals or what they listed. They want to avoid probate, make things easy for the family, avoid taxes, leave things the right way. They have perhaps a business or certain assets that they want to leave to certain people. And so then what happens is we send you an email with a calendar link. And so again, this is part of where we try to use, technology where we can to just minimize the back and forth. Hey, are you available on Tuesday at 3? No, but I'm available at Monday at 4. Oh, we're not available Monday at 4. How about Wednesday at 9? No, can't do it then. And then so what we do is we send those prospective clients a calendar link. Looks just like this. So it's a link to my calendar, and our prospective clients, once we've reviewed their questionnaire, they can go on here and say, you know what? They say, I am available on June 5th, and I think that 4 o'clock would be a good time for us to have a chat. So then you just fill out that information, you submit it, and that what we call that estate planning design meeting is scheduled. It's on our calendar, it's on your calendar, and it's going to be a Zoom call. And so that's step one is that hey, I need to do something. I'd like to have a conversation with Paul or with an attorney. What do I do? Hit link, fill out questionnaire. We review questionnaire. We send you a calendar link. You find a time that's convenient for you. And then you submit that, and it's on your books and it's on our books. Okay, so what's next? Next, we will talk about even gathering a little bit more information now, because we already have information on whether you're married, whether you have children, what are the main assets that you own. Maybe we have a little bit of information about the kind of fair market value of your estate. You were able to write in a text box any unique circumstances that you have that you want to make sure get addressed. But now you've scheduled the meeting. So what can we do ahead of that meeting to make it even more productive? So again, using technology, we're able to do some things. What we do is we send you a link so that you can create your secure estate planning portable. This is a sample one for Fred Flintstone. So we send you a link, you set up your username, your password, it's very secure, it's encrypted, and you can start entering some information here. So some of the information that people enter in here even before we have that discussion, I love walking into a Zoom meeting that I have with someone, and not only their initial questionnaire is complete, but also their secure portal has been populated. Now I can almost feel like I know these people, and we haven't even said hello yet. So, here's the information where you can put in all the kind of stakeholders or participants who may inherit from you, may play a role in your estate. You can even put in your financial advisor, your CPA. The idea here, once we're done, anything that people may need when you pass away, it's all in one secure online location, and they're not having to fumble around with a bunch of paperwork and bank statements and brokerage statements and hard copies of wills and trusts. It's all right here. You'll have the hard copies. We'll talk about that in a minute. But this is a great place. A lot of people that we help, they may have set up their own revocable living trust many years ago, but it needs to be updated or redone, or as we call, restated. So this is a great place where people can upload, documents that are important to them in that secure portal, so that we can review those important documents prior to having that first discussion. Also, another key is kind of documenting what assets you own. Again, so much legwork is taken out of the process by you populating this information in advance. So here's where you can populate, what's your real estate do you own? Who is it owned by? What's the fair market value? What are your retirement accounts? You have other brokerage accounts? Do you have a business? All that can be populated in here. And so that way, once we start talking, we get right to it. And I'm able to say, look, I read over the information that you put in. I realized that, here's your circumstances. Here's what's important to you. Now let's jump in and start talking about some of those things that are most important to you. And I can start asking you questions and we can really be productive in a limited period of time. So all that's real helpful. And again, some people either they don't get around to it prior to that actual Zoom design meeting, which is the next step, or they don't complete it. Some people are a little uncomfortable kind of sharing all of that information with someone like myself before they've ever met me. That's okay. It can all be populated later if things go well and you kind of get to where you know, like, and trust me or whoever you're dealing with. And then you can populate that information later, but it's all secure and you'll have your own username and password. All right. So that's kind of that's step one and two. One is the questionnaire, calendaring the design meeting. Two is uh, your what we call your decision vault, secure online estate planning portal where information can be shared between our office and you. And then number three is the actual estate planning design meeting, where we send you a link for a Zoom call. It looks just like what you're looking at right now. We're actually on YouTube live here through a Zoom meeting. So we send you a Zoom link. You get on it. Of course, if you're married, your spouse will also be on it, and there'll be two screens. There'll be the screen of me talking, and then there'll be the screen of you and your spouse. And so that's where, hey, nice to meet you. Saw where some of the information that you shared that was very, very helpful. Want to get an overview from you guys as to whether there's anything else you want to make sure we cover as part of the important task of getting your estate in order. And that we just start that discussion. I kind of lead that discussion. Mainly what I'm doing, I'm asking questions, I'm listening to your answers. Things like if it's a married couple, okay, let's start with this, even though we're not really going in chronological order. I may say this is a good start for us to address all of what we need to address. I might say, look, if in the unlikely event you both pass away, talking to a married couple, and so yeah, I mean, I'm not that blunt where you're both dead. What happens? But we do it in, of course, a kind of a tactful and professional manner. But just to start the conversation with a married couple, sometimes I'll say, well, actually, that's why we're here. Let's talk about in the unlikely event you both passed away at the same time, how would you want things to go? Even though it's not likely to happen that way, the answers to that question can start to get us where we want to get, even though it's much more likely that one of you will pass away first and then another one will pass away later. So then we'll talk about under that kind of hypothetical scenario, if they both passed away at the same time, how they want to leave things. Do they want to leave it to the kids equally? Do they have any other kind of goals from how they leave things when both of them pass away? Does anything go to the grandchildren? Does it go equally to the children, or do they leave the business to one child because they worked in it, and or the house to one child because that child needs a house to live in, with other assets going to the children equally? All those things. I kind of lead that discussion, ask you questions, also questions about who's going to handle all this when both of you pass away, who's going to be that executor, that successor trustee who can make sure that everybody gets what they're supposed to get in accordance with your wishes that we're going to lay out here. So just starts the estate planning design meeting. There's so much more to the design meeting than just what happens when you both pass away. It's how spouses leave things to each other. There's tax issues involved. There's all the, if you're incapacitated, who's going to handle your money, who's going to make your medical decisions. And so, not to mention any unique circumstances that you might have. Those are probably ones that are most important that we kind of dig deep on to make sure that those things that are on the top of your mind that you want to make sure get addressed the right way. So that's part of that estate planning design meeting. At the end of that, or throughout that estate planning design meeting, I'm likely to be kind of recapping and summarizing some things and maybe saying something like, okay, let's call them John and Jane Doe. So it sounds like this is where we are so far. Sounds like when one of you passes away, you don't want anything to go to the children right then. You want that surviving spouse to stay in control of everything. And again, we get into what that really means. And then after both of you pass away, sounds like you want things to go equally to the children, but it's going to go in a trust for them so that if they do get divorced, they'll be able to keep their trust and those inherited assets won't get commingled with other assets that they have with their spouse. You said you wanted your oldest child to be that successor trustee of that trust, will set all these things up to avoid probate. So anyway, throughout that estate planning design meeting, I'm always summarizing and recapping and really making sure that, and really doing it in terms that are easy to understand, so that those prospective clients, they never get lost. And I'm sure if you're, I've heard from clients varying opinions of their conversations with other lawyers. Sometimes people say, I worked with this other lawyer, they were fantastic, but they moved, they retired, whatever. Sometimes people will say, well, we just didn't hit it off with this other lawyer. It didn't seem like they really had a good understanding of what they were talking about, or maybe the prospective client said something like, they really spoke over my head and we really didn't understand all of the legal terms that they were using. And look, that happens. I get it. It's a complicated area. So anyway, that's the idea of that estate planning design meeting. Towards the end of that estate planning design meeting, I'll probably give you a good summary of everything that we talked about to make sure that I didn't miss anything. And I'll quite frankly ask you, was there anything on your list of questions, if you had a list of questions that you wanted to make sure that we address before, we continue to the next step? We want to get to a point where they're like, boy, no, this sounds like exactly what we want. So then what I'll do is, people obviously and deserve to know what's involved to hire lawyers and put their estate planning in place. So we'll go through that, everything, at our firm, and many lawyers do this estate planning legal work on a fixed fee basis. Some lawyers do it on an hourly rate basis. I'm not here to say one's better than the other. It's just, I can tell you ours it's a fixed amount. We've done this so many times, thousands of times over. We have an idea of all the work that we have to do and what's involved. And quite frankly, consumers prefer to know kind of exactly in advance what's involved from a legal expense perspective to getting all of their estate in order. And oftentimes, our clients, they don't blink because they realize perhaps the two probate expenses and the probate delays that they're avoiding by having things in place. Those probate expenses, not to mention all the hassle and delay factor, those expenses far exceed any kind of expense of people getting their things in order. But the expense does vary based on a number of different factors. And so really in this YouTube live, I'm not going to go into kind of what a particular is, because but I don't want to mislead anyone, but I can tell you that no one has to move forward until they know exactly what their circumstances kind of warrant and what is reasonable from a legal expense standpoint to meet all of their estate planning objectives. Okay. So after that, sometimes I'll ask the question, you're ready to get started. And most of the time the answer is yes. And so from that point, we gather a little bit more information, make sure we have all of our answers. How much information we need to gather then can depend on how complete they were with their, as I'll show you, with their initial, portal information. If they really populated it well, there's not going to be a lot of additional data that we need to get. And if they filled out, let's see, let me show you there. If they completed their initial questionnaire thoroughly, and then they populated their online portal with their children's names and other people's names and their financial information, really not a lot of additional information we need to get. There's throughout the process, we may need information. And as we just need information, like I tell clients, if it's just data that we need, we'll email you. What's so-and-so's middle initial? What's the last four digits of your social security number? What's your birth date? If we don't have all that with the information that you populated, we can get a lot of that by email. That's the easiest way to do it. However, if some new issue comes up during the estate planning process that requires some substantive discussion, hop on another Zoom call. So, and we'll talk ourselves through it to get, again, we want you feeling really, really comfortable. So again, we're doing this for people all around the country. And we're able to do that because of something of the part of the process that I'll show you here in a moment. So, all right, so let me recap where we are so far. You've kind of a ding went off in your head. I need to get my estate legal affairs in order. Maybe you're saying, like many people tell me, I've been watching Paul's videos. Maybe you're saying, he explained things that I learned a lot by watching Paul's videos, is what a lot of people tell me. I want to give Paul an opportunity to help me get all of this in order. He's got this national law firm. You sign up for you request your Zoom design meeting. We review the questionnaire. We send you the calendar link. You schedule a time on my calendar that works for you. I'll see you on the Zoom call. We send you a link. You click the link. You're on the Zoom call with me at the agreed upon time. I lead that discussion, mainly asking you more questions and asking you the right questions and listening very closely to what your answers are, so that I can ask you the next right question. And along the way, I'll be recapping where we are, making sure you're good with it, and then ultimately kind of letting you know what's involved to go from start to finish to getting everything in order. If that sounds great, we gather additional information. Step 4 of our 9-step process is we got to prepare everything. So now we've got to get to work. And so typically when we create an estate plan for a client, and I'd say overwhelmingly most of our clients are married couples. Of course, we get our share of unmarried or single people as well. But I think just across America, when people kind of initiate this process, more often than not, they're married. So we've got to prepare for that married couple. Typically, and everyone is customized and everyone is unique, but we'll prepare oftentimes that revocable living trust for a lot of reasons, to avoid probate or to provide for the continued management of assets after you pass away, or after you and your spouse pass away. Appoint your successor trustee to handle everything. Your pour over wills, which I'll show you in a minute. Your financial or general durable power of attorney, healthcare documents, show you all that in a minute. So we got to get to work preparing all that. And again, our firm built its own, because we do this work nationally, and we generally have this thought process of trying to keep things as efficient and as simple as possible. So I'm a member of some organizations that provides, nationally, some document preparation software that do wind up churning out, your 150-page trust, because they want to cover every possible scenario that any kind of American could incur. We're a little opposite. Not that there's anything wrong with that, but our mindset is, let's cover what our clients need to have covered and all these reasonable contingencies. But let's not confuse everybody and turn and create a 150-page trust when we could have accomplished the same thing and maybe a 10-page trust. Who knows? So, but we'll give it the level of complexity that it deserves, but also the level of simplicity, so that the lawyers, clients, heirs, beneficiaries, trustees, CPAs, financial institutions don't get too confused. All right. So we prepare those. And so that's step 4, is our preparation and customization of the legal documents. Next step is moving on to the review. And so, not that we expect you to understand every word that is required to be in all of these estate planning legal documents. Very common terms that are used in legal documents, but never used in a layman having a conversation with someone. I leave my estate to my descendants per stirpes. I bet you've never told anybody that you want to leave your estate to your descendants per stirpes. You probably said, no, I think what we'll do is we'll leave it to our kids. And so, but in legal documents, sometimes to accomplish what we need to accomplish, we have to use words that aren't used typically, but they have the right meaning, and the application of them is exactly what you're trying to accomplish. For example, descendants per stirpes, you have 3 kids, you leave things equally to your 3 kids, but let's say one of your children winds up dying before you, and that child has 3 children. Well, when you leave your estate to your descendants per stirpes, you leave things in three equal parts. And then because a child of yours died before you, your two surviving children will each get one third. And then the children of your deceased child will split one third. So, which, again, if we talked about that and that's what you'd want to happen, we make sure we accomplish all of that. So, nonetheless, there is likely to be some legal jargon in those documents, but we got to do what we got to do, and it's all in your kind of best interest to do that. So, step five is that review, and I'll call it the Zoom review and the attorney participation. So, let me show you a couple things here that as I share my screen. This, for example, if we were doing this for John Doe and Jane Doe, we'd pop up their trust on our Zoom call, just like we're doing, and we say, "Okay, John and Jane, here's your trust." We'd scroll through it, and we'd show them, "Okay, here's what happens when one of you dies. Here's what happens when the survivor of you dies. You're leaving things in a trust for each of your kids to make it divorce proof. Here's the successor trustee of your trust who's going to handle all of this when you pass away. Here's what all those trustee rights and duties are." So all that is in the and we kind of scroll through, we highlight certain things, particularly if you said, "I want to leave, I want to make sure my business goes to this child." We're going to point that out to you in the trust instrument that we customize and be able to show you, "Okay, here's where you left your business to Sally, and here's where you left the rest of your estate this way." So we want to point out all those customized provisions. And what we see when we do that is we kind of see their shoulders start to drop. Okay, I think they got it. Boy, they everything we talked about, I see where it's been customized. In addition, here's, for example, John's last will and testament. Even if people have a trust, they also have what's typically referred to kind of slang version as a pour over will. And so, kind of the key provision here is if John does own anything in his name, you see his trust is going to cover how the trust assets, the assets titled in the name of his trust dictates all of what happens to the trust assets when John dies or when Jane dies. But maybe John had some assets that weren't in his trust when he died and they were in his name and they didn't have a beneficiary or anything like that. Then we need to use his pour over will. The goal oftentimes when people set up a living trust is to never have to use the pour over will because there's nothing in your name that needs to be transferred, that there's nothing in your name when you die that gets frozen, that we have to go through probate to get transferred into your trust so that your successor trustee can then disperse those assets to your beneficiary. So this is kind of if there's something in my name, and why would there be something in your name when you pass away if you have a living trust? Maybe after you set up your trust 20 years earlier and funded your trust, transferred your home to your trust, transferred your accounts to your trust, maybe you opened a new account in your name, not thinking, "Hey, I should have opened that account in the name of my trust." Maybe you bought a new piece of property and you bought it in your name, not thinking, "Oh, I should have bought it in the name of my trust to avoid the probate." Maybe you started a business and you started that business in your name, that LLC, and "Oh, I should have had my trust be the member of that LLC." So there's something in your name when you pass away. And so what this does, this bequest to trust is where kind of if there are assets in your name, you leave them to your trust, name your executor, all that's part of your will. In addition, what we go over, we'll go over where you customized who do you want having that durable power of attorney. This is a sample Texas form on, Texas is one of those 30 states or so where its legislature created a statutory power of attorney, where the legislature created a power of attorney that most banks, financial institutions, title companies, they're all familiar with it in Texas because it's one the Texas legislature created. So we'd walk you through who you named in this case. Let's see, John Doe, he appointed Jane Doe, his wife, as his agent, and he listed what authority he'd want her to have, or maybe he'd want her to have all of the authority. Maybe he named backups, the backup, which is in here somewhere. It's, let's see, Susan is the backup. So she's that backup agent. So anyway, all that we get on that Zoom call after it's all prepared and customized, and we point all that out to you. Of course, there's the healthcare and called medical power of attorney, designation of healthcare agent. And so here's who you name, your backup. Here's what authority they have. Again, Texas kind of statutory thing here. And so we go through that with you. And then, so now at that point, like, okay, does all that sound like kind of what you're thinking? And usually it's, the case of, yeah, that's exactly what we wanted. Sometimes they'll say, you know what, after we talked, we thought about this. And sometimes we've got to make some adjustments to the documents. Not unusual, and it's okay and acceptable for people kind of throughout the process, because as you go through the process, you learn things, you learn rights that you have, you learn new aspects of estate planning. And so sometimes you walk into the 9-step process thinking one way, but once you learn about what options you have, you may wind up doing things a different way. So, for example, one of those where people go into something thinking, let me just leave it outright to my kids. But then when we bring up okay, do you want to leave it to them in a way where it's protected in case they get divorced? Perhaps you want to leave it in a trust for them so it won't get commingled with other assets they have with a spouse. Sometimes people say, okay, I didn't think I would want to do that, but now that I'm going through the process and I'm learning a few things, then yeah, let's talk about going in that direction. All right. So again, recapping where we are, requested your design meeting, you picked out a time on the calendar, we had the Zoom design estate planning design meeting, we customized all the documents, we had another Zoom review meeting. If you're domiciled in a state where one of our staff attorneys is not licensed, we'll get an attorney who is a member of our co-counsel network that I recruited and vetted. We'll get them to participate. We'll have an electronic version of all your objectives, and of course, we'll have an electronic version of all the documents. They'll participate, reviewing objectives, reviewing documents, ensuring state compliance. What we need to do anyway to make sure that we can help people around the country by having our co-counsel participate. So that's all been streamlined, and they've all been trained. They know what to look for, and that's a smooth process as well. Then the next step is simply making it official by getting the appropriate signature. So I mentioned earlier here that we use a combination of technology where we can, and we can really streamline things and make things efficient using technology. But unlike maybe the financial services industry, where many financial services firms will enable you to go online and change a beneficiary on an account, we don't have that in the estate planning area. We have it under some very unique circumstances, but really it's all done wet signature these days with estate planning, all wills, trusts, powers of attorney. Sometimes people just tell me, Paul, send it on over and I'll give it the old e-sign. Can't do that. The estate planning legal services industry just is not there, right, wrong, or indifferent. They're not there. So when we have reviewed everything and everything looks perfect, then my staff assembles everything. Every one of our clients gets we call it their estate planning portfolio. And we send you all of the documents with what I like to call assign here sticky tabs. And so you'll get yourself in front of a notary or in front of a notary and witnesses, and you'll sign where you need to sign, wherever the sign here sticky tab says sign here. And of course, you'll get everything notarized and witnessed. And then we're not done. So again, taking advantage of some technology, we want to make sure, as I show my screen, we want to make sure that you may have the best of intentions of securing your wet signature papers in a safe place. Been doing this for 33 years. Even the people with the best intentions, they wind up passing away. And then the son says, Paul, my dad showed me where the paperwork was. It was in his closet. It was in the binder. My dad brought me to the safe deposit box. He had put it in there. Or, Paul, my dad gave me the combination of the safe and said his will and trust and power of attorney was all in there. He passed away last week and we can't find it. And you know what? Especially if we have to probate a will, it can be a disaster if the original can't be found. Lawyers typically don't retain any kind of hard copy of the documents that their client signed. Electronic copy, yes. Physical copy, unlikely. And so it's tough, because if someone, you may sign your last will and testament. You may not die for 20 or 30 years later. And if when you die, can't find it, and it's more common than you think. In the old days, I used to think, how in the world could a family lose their father's will? How in the world? But look, people move, whatever. There's any number of reasons where original wills get lost. And when someone dies having signed a will, but then the original can't be located when they die, then the law presumes that the law presumes that during their lifetime, they destroyed their will with the intent to revoke it. So now the heirs have to, if they do have a photocopy, which they often do, they have to overcome that presumption. It's not a guarantee, but that they have to overcome that presumption that the person destroyed the will with the intent to revoke it. So one of the things we want to make sure that we do is always have, an electronic copy. And I would say it's probably not good enough just to have your lawyer have an electronic copy, because again, sometimes these documents are in effect for 20 or 30 years. Your lawyer might not be around, may have retired, may have done whatever with their files. And so, we give all of our clients their secure portal. They can upload the documents. They can send them to us. We can upload the documents, but there's one where Fred Flintstone, at least his life insurance policies, his annuities, all of his trust documents, wills, powers of attorney, all his certificate of trust, and any kind of relevant estate documents are all an electronic version is stored in their secure online portal. And maybe Fred and Wilma Flintstone added their oldest child as a user on their Decision Vault account. So if Fred goes into the hospital and the hospital saying we need to see an electronic copy of Fred's medical power of attorney, then the daughter can pop it up right there. Because it's in their secure portal. You're not scrambling to call law firms. You're not having to go home or go into the safe to try to make a copy of it. It's all right there. So I've always been surprised at how kind of disorganized things can get. And it's usually when there's a lot of stress going on in someone's life that they need to access the documents. And if they can't find them, it creates a lot more stress. So great idea to have a secure online place where things can be stored. All right, there's a couple of other pieces I want to share. That was, uploading the signed documents was step 7 of my 9-step process. Let me go on to step 8, and this is a very unique aspect. Pretty sure, again, not that my process or our law firm's process is any better or worse than any other law firm or any other attorney's process. There's some great estate planning attorneys out there. I've met them. I like them. I know them. I know they do a fantastic job. But here's one piece where, I built this and I'm pretty sure nobody else kind of does anything like this. Yes, we're a little bit unique and different, but one of the things that we give all of our clients access to, because you really can't just set it and forget it. And, estate planning, unfortunately, is not a one-shot deal. People's life circumstances change, laws change. And so one of the things that we offer our clients is to be a member of what we call our impactful inheritance community. So our clients get a kind of a 1 year free subscription to this impactful inheritance community. There's a lot on here. So the client would request to join, we'd approve that they were a client. And so a lot in here. This is something that me and my staff maintains. So this is a place, the best way I can describe it is there's a lot of resources here. There's lots of people in the community that you can engage in conversations with. It's not just me, and it's not just our law firm employees, but lots of people who share similar life circumstances are talking to each other about how they're addressing particular issues. And it's just one big community of people getting together, all who have that like-minded goal of trying to protect what they have for themselves and for their family in the future. So A lot of different pages, a lot of different resources in the community. Here's what's called the discovery page, which is kind of the featured posts and some upcoming events. Here's our events. We've got some coming up here. So again, all of our members will participate in these live events. And here's kind of the latest activity, which is a feed of maybe some of the most recent discussions that have been going on in the community. So a lot going on there. There's ways where you can find other people in the community and have direct messages with them. So it's a really cool piece that's growing as we put it out there, and clients are taking advantage of it and going to take advantage of it to belong to a network or community of like-minded people, talking to each other, participating in events. So that's just, to me, it's step 8 of the 9-step process of ensuring that your legacy is left the right way. And then my step 9 is, and this is you'll use your discretion here. Step 9 is, if I had to describe it in one word, it would be communicate. Um, and this can be done at any time. It's often done after parents go through the process. Maybe you sit one or more of your children down and you tell them, hey, this is what we did. Not only this is what we did, but this is why we did it. This is why we left everything to the kids equally. This is why we appointed Sally to serve in this role on power of attorney or trustee or executor. This is why we chose this person to be our medical power of attorney. They're in the medical field. They live down the street from us, or whatever your decisions might be. And it's opportunity for you to communicate, some of those things that potentially could cause some funny feelings in the future if it's not communicated now. You get to communicate that now, perhaps get some feedback, mediate some conversations if necessary, so there's no surprises in the future. It seems like problems surface when somebody dies, either when there's surprises. Hey, I didn't think it was going to happen this way. So because it didn't happen this way, it's not fair and I've got problems with it. Or problems surface because people don't trust each other. And like Ann Lander said, whenever you want to get to know someone, share an inheritance with them. So sometimes that um, family members not trusting each other causes problems. However, the communication that you could have during your lifetime, facilitating those conversations. Some people will say, I'm not going to tell anybody anything. They'll know where my paperwork is. And you know what? If they got a problem with it when I pass away, it's not my problem. I'll be dead. That's what people tell me. I'm not, don't shoot the messenger. Or other people will say, yeah, we just talked to these people. I told my successor trustee that one of my children where the paperwork was, what we did, and they'll take care of things when we pass away. And others will say, we get everybody. We talked to everybody about it, and so we got some feedback. We talked through a few things, and everybody's good with it. And so there's not going to be any surprises down the road. So I think that communication is one part of that, what I call 9-step path to securing your legacy. So make sure you take advantage of that. Okay, what I want to do now is I want to hop on over to, let's see, any kind of important questions or comments. And I've got it on a different screen here. Hey, Trevor, Colby, of course, Larry, Whitney, all good. How often do you go live? Can you help clients in all states? So yeah, I can help clients. And I think once you open your questionnaire and request that design meeting, you'll see where we listed about 5 states where, because of their lawyer rules of professional conduct, we just can't. So, but if you're in one of the other 45 states, we go live pretty often. So it just varies. You'll have to check the YouTube channel. But even when we go live, the recording of the live stream is permanently on our YouTube channel. So even if you miss live, we got it. How do you keep in a house and a trust for 3 kids to manage as a rental? That's a good question. In fact, I skipped a couple. So I'll go back to those after I answer this one from KC. So maybe John and Jane Doe, who have 3 children, say in their trust, John and Jane Doe say, after we both pass away, our home at 123 Sesame Street, or it might say whatever home we reside in at the time of our death, or they might designate a particular home depending upon what they're trying to accomplish. That home will remain in trust. Sally will be the trustee. The trust will be for the benefit of all three of our children. And that trust will last for a certain period of time to be determined in the trust instrument. May go on for the children's lifetime, who knows? And so now with Sally as the trustee of I'll call it a subtrust, a living trust subtrust, John and Jane created their living trust. And in the living trust instrument, it said what happens to the house after both John and Jane die. I'm going to call that a subtrust within John and Jane's trust. So after John and Jane die, Sally is now in charge of managing the rental property. She's the trustee of that subtrust. She collects the rent. She deposits that rent into a subtrust checking account. She pays expenses of the property out of that trust account. Maybe if there's some net income that gets paid out to the three children who are equal income beneficiaries, maybe. So that's how you keep a house in a trust for three kids to manage as a rental. You name one person, and again, you get to control who that is. So you're going to pick the right person. And it doesn't have to be one, but you'll likely designate a trustee or co-trustees who are in charge of managing everything that has to do with that rental for the benefit of the three trust beneficiaries. Let me go back. Are IRAs that transfer to a spouse directly upon death considered part of the estate? Okay, good question, Trevor B. So let's say John has a $2 million IRA and you say a spousal beneficiary. So John is married to Jane. And so John listed Jane as the 100% primary beneficiary. I'm going to give you the technical answer, Trevor. So that $2 million IRA that John had when he died, it's part of his gross estate for estate tax purposes. So let's say the IRA was worth $2 million and all of John's other assets were worth $8 million. So now John has a gross estate of $10 million, the $8 million of other assets, and the $2 million IRA. But because he named his wife Jane, his spouse Jane, as the beneficiary of his IRA, his estate, for estate tax purposes, gets a deduction that's called the unlimited marital deduction. So now it went from a $10 million gross estate, $2 million marital deduction. Now it's an $8 million net estate, and that net estate may even be reduced further depending upon how John left the remaining $8 million. So it's included in the gross estate, but gets deducted from the gross estate before the net estate for taxes is calculated when a spouse is a beneficiary of an IRA. Hope that helps. Good to see Surfer Girl from Vermont on. Fantastic. With three kids, don't want a 2 out of 3 vote. Good, KC. I guess that goes on with your house thing, so it's too unfair. So yeah, sometimes parents do say, I want these assets managed after we pass away in 2 out of 3. You don't want that. Maybe you just want to name one to be in charge. And that's the example that I gave. My G says, my mom passed away. Dad passed in 2011. Recently, we found out upon the reveal of the last will and testament, LWT, that several codicils were made. And it's likely my mom was by no means of sound mind. I guess you're wanting me to comment on that. So, all right. Mom died. She had a will from back when, and then she changed her will by making codicils, and you don't think she was of sound mind. So you've got a tough task because you got to prove it. If you don't want those codicils to, if you think that mom perhaps failed to have the capacity to understand what she was doing, or as you say, she didn't have that sound mind, you got to prove that she didn't. How do you prove that? It's a tough one. So it's likely those codicils were probably signed in the presence of a notary or witnesses. Maybe she went to the doctor around the same time that she signed these codicils. So you have to prove that she didn't have the capacity to understand what she was doing when she signed her codicils, or perhaps you have to prove that she was perhaps influenced by someone. So that's a tough one, but you'll have to do that through perhaps the testimony of the people who were present when she did it, perhaps the doctors that examined her around the time that she did it. And so again, that's a court proceeding, and so you got your work cut out for you. All right. So yeah, gee, I probably should have read your next. Can changes like this be null if in fact, yeah, if in fact it was the case that she didn't have the sound mind or the capacity, yes, they can be null and void. But you can't just say she didn't have the capacity. You have to prove it under all the standards that the law requires you to prove it. So good question. All right. See, can you speak to people who may not be savvy to be able to download documents, but may be able to fax? Sure. You know, my entire professional existence for the last 33 years has been dealing with, I'll be blunt here, old people who just aren't, not in all cases, but in many cases, aren't as tech savvy as their grandchildren. So yes, we do what we have to do to get things done. If we have to use mail, in your case, fax, um, most old people, and look, it's not an insulting term; it's just a true term. But we're at a point now in the year 2024 where even most old people can handle some email. They have an email address, or if it's a married couple, one of them has an email address. Sometimes if they absolutely have, they've just refused to get into the 21st century, they have no email, they have no smartphone. In those cases, sometimes they get a child involved to help with the communication. So that happens sometimes. Sometimes we have these design meetings on just a telephone call. Sometimes it's on a speakerphone if it's a married couple. They just again, they'll have their iPhone or their smartphone or their flip phone. Maybe it has a speaker, maybe it doesn't. But sometimes we just do what we have to do because we deal with the elderly and who aren't quite as tech savvy. So yeah, we can deal with it. All right. Trevor says if Fred has set up an estate plan, but Wilma hasn't made any arrangements, then they both pass at the same time. Do all Wilma's assets go to Fred's estate or probate? Question. Your state likely has these rules that says if two people die at the same time, who does their estate go to? And so we'd have to look at those default rules. Yeah, you said they pass at the same time. So maybe based on one being older than the other, and they're older than a certain age or younger than a certain age, there's this presumption that maybe the younger one survived the older one. And so in that case, if Wilma is presumed to have predeceased Fred, then um, then then that's how the law plays out. And maybe some of Wilma's assets do go to Fred or to Fred's estate to ultimately go to Fred's heirs. Or maybe based on the rules that apply, it's presumed that Fred predeceased Wilma. And if that's the case, then none of Wilma's assets go to Fred or to Fred's estate because it's presumed that Fred died before Wilma. So now things go to Wilma's other heirs. Okay. Hello, SW. Hello, Domingo J. Herrera. Nice to see you. I don't think I've seen that name before. All right. Let's see if we have anything else. I think that about wraps it up. So, look, thanks all of you for letting me share this information with you. Make sure you like, subscribe. I will mention if you want to go to the description of this video, I have a couple of things that are pretty easy to take advantage of. We started recently our Impactful Inheritance newsletter, which is done through LinkedIn. So I believe in the description there's a link where you can subscribe to that, no expense. And that way you'll get some of my postings that I use LinkedIn to provide. So, all right, let's see. I think that's it for today. Y'all have a great evening.